So, as always, we dedicate the share to, or for a speed refer for all the cholim having treatment and recovering from procedures, and to the soldiers that they should be successful and return home unscathed, and for the release of the hostages. So, this week's Parshat Yitro, or Jethro, as they say in English, it discusses the Ten Commandments, and Yitro actually was a convert to Judaism. I don't know why there must be some significance, but in that his name is attributed to this parasha. But what I wanted to discuss was one of the Ten Commandments is thou shalt not steal, and thou shalt not in that included kidnapping. Now, kidnapping is considered like stealing, which is interesting. It's one would thought maybe that could have been like a sub commandment not to kidnap, but it's included under stealing. And I'll just read something here. It's actually the eighth commandment. You should, and it refers. It says here in the commentary. It doesn't talk about stealing articles. It refers to kidnapping for some interesting reason. And it's obviously very topical now with what's happening in Israel. And it says here, Mechilta compares all forms of stealing to the third commandment, because one who steals may well seek to cover his tracks by swearing falsely. This commandment alludes to many forms of behavior that are morally related to theft. Thus, failure to respond to a greeting is even a theft, is even considered theft to a man's self-respect. And to win someone's gratitude is a form of thievery. So, I mean, it can go, you can take it to the nth degree, but it's interesting that the kidnapping is stressed in quite so much detail here, or discussed in detail here, due to the current situation here. So, and it discusses it more, just shows how serious it is, as serious as actually stealing articles, maybe even more serious, because maybe what could be done is the person could be kidnapped, could be sold into slavery, and be forced to serve worship idolatry, which is always on many occasions. Hashem doesn't like it, and it's many times in many parashiot it refers to that thou should not serve other gods, in the Aleinu and in the Shema many times. So maybe that's why it's also stressed in terms of theft.
So we learned in Sanhedrin that a person is chayiv misa for kidnapping. It's not just of normal theft. So that, I mean, that's exactly what Kevin said. There's a heck of a lot more to it than just normal theft. Just one question. Just as a matter of interest. Okay, so we were at the 116th stuff. Look, generally, if you want to look at the kidnapping, Gavin, it was the 86th stuff. There was a whole teaching by the Tanna Kamma and Rabbi Shimon, and what does it mean? Is it about reselling the victim? Is it about keeping them for your purposes? It's a whole discussion. You remember?
Let's see when you talk about it.
In the 86 stuff. Well, it's not the subject of tonight, but I'm saying look in the 86 stuff of Sanhedrin. You'll see there's the Tanna Kamma and Rabbi Shimon's opinion about kidnapping as being chayiv misa for the death.
No, I remember us covering kidnapping. I don't remember the detail. I know it's quite hectic.
Yeah, no, but I'm saying look at it in the 86 stuff.
Oh, yes.
I don't remember if it was an aleph or bet.
More hectic than normal theft or standard theft,
Absolutely.
as we know it, like stealing.
Absolutely, yeah. Although Goy is chayiv misa for normal theft, but there are rules that apply. Terms and conditions applied, as they say. But Gavin, look in the 86 stuff, you'll see it. That's what we did. You
No, I
remember?
believe you. You got it right. You got it. I remember, but not well. You remembered well.
Okay, well, it's just because I do this. All right. So, guys, we're in a new issue now, and the Mishnah states, if he poured out the wine, he said to the owner of the honey, I will save your honey, but you must give me the value of the wine. So the owner of the honey is obligated to give him the value of the wine. And the Gemara asks, okay, it says it in the Mishnah, but let him say to the owner of the wine, I was actually only joking with you. Do you really think I was being serious? I'm never really meant to pay you for the wine. So we want to say, well, is there any merit to that discussion that you can renege on the deal? And it was taught in a brisa that there was one who was fleeing from prison, and before him there was a ferry boat. Okay, and he said to the ferryman, "Look, take a dinar and ferry me across the river." So what obviously was fearful of being recaptured, and he was in a hurry to escape and cross the river. He's not going to swim. There's no way he'll survive that. It's not like he's got a life jacket. So he therefore offered the ferryman a dinner, which was an enormous amount of pay to be ferried across the river. Right? But when it comes to the actual court case, when he doesn't give him the dinner, the ferryman receives only his fee. So what do I mean on his fee? It's the usual fare for ferrying a person across the river, not the dinner that the passenger promised. Now, the first thing that should come to your mind is that, firstly, why wouldn't he, why wouldn't he just do it for his normal fee? And the answer is that the boat might have been departing at 2:30, at 14:30, okay? And this guy at 14:15 might have wanted to get out of there in a real hurry before the prison guards came after him. So he said, listen, I'll make it with you well. I'll give you an astronomical sum. Okay? Otherwise, he would have paid, if the ferry left with a number of people, a certain amount of money. So the Gemara says, well, why would the Gemara doesn't say this, but it's obvious that it would go to court. And how could it get to court if you're escaping in a prisoner? Meaning, if a prisoner escapes, then surely the court would send him back to prison. How could he have a prison case? How could he have a case as a prisoner against the ferryman that helped him escape? So let me just add a little bit of background here. Is in Sanhedrin, while we're on the subject, Gavin, on the 73rd daf in Aleph, there's a mitzvah of rescuing somebody from danger. And in a way, it's almost like returning a lost object. So therefore, the ferryman actually has an obligation to assist the prisoner in his escape. So obviously, the only way he's got an obligation to do it is if he was not jailed by a Jewish court, but he was maybe jailed unjustly, Kevin, by an occupying power or the like. He's in Rome, they're in Babylon. Babylon's a vassal state of Rome. They kidnap this, they throw this Jew in prison. A Jew's got an obligation to help another Jew. We're not saying when a Jewish court convicts a person, we're saying that it was a punitive sort of imprisonment. Okay, so because the Jew is entitled to is obligated to help his fellow Jew, he's really Arthur not entitled to anything more than the usual fee for the labor, which is the usual ferry boat fee he would charge anybody else. Okay, he refused to fulfill his obligation, and he basically saw a wonderful business opportunity here. So therefore, he compelled the prisoner to promise him the inflated sum of a dinner. It wasn't the prisoner that chose to obviously pay an inflated fee if this is the ferryman's standard fee. But because the demand runs contrary to the ferryman's obligation about rescuing a fellow Jew, then the passenger's promise isn't binding. Because he can say to the ferryman, I was joking with you. According to Rashi, that basically in the Ravad, it's saying, listen, did you honestly think it's fair to charge me more than the fee that you charge for anybody else just because I'm in a invidious position? So one who fulfills the mitzvah of returning a lost object generally doesn't receive compensation even for his labor. What is the circumstance upon which he is entitled to his labor is if he would suffer a loss of income thereby, as the Ramah says. Meaning he could have used that time to charge for services rendered, and he used that for a mitzvah, and he's actually actively suffering a loss. But nevertheless, the ferryman has an ongoing business of taking people from one side of the river to another. So therefore it would be unjust to deprive the ferryman of his regular fee simply because he happens to be in danger. So the prisoner is entitled to pay the usual fee. That's fair enough. He's not entitled to say, look, you did me a hell of a mitzvah. You shouldn't charge me at all. All he has to say is, listen, you cannot take advantage of me in this situation. I'm not expecting you to lose money, but whatever you charge any other passenger, charge me. So that's according to the one approach. According to the other approach is that the passenger's exemption is in no way connected with the ferryman's obligation. Listen carefully. Because he is exempt basically because he was compelled to offer this outlandish fee. Why? Because he didn't want to return to prison. Basically, the ferryman had him by the short and curlies and could negotiate whatever price he wanted it. So when you promise an inflated fee because of a compelling need, and not because you truly see the service worth the money, the promise isn't binding because it wasn't made sincerely. That's what we say, but I was only joking. In other words, if you take the urgency out of it, there's only a certain amount you'd pay to go from one side of the river to another. Anything more that a person takes advantage because of the just need is not what you would deem valuable for the service in and of itself. That's the other opinion maintained. Now, not everybody agrees with that opinion either. Why? Because if you look at a practical difference between the two approaches, let's just take a doctor for a second, right? According to the first approach, where Rashi gives a commentary, a doctor is obligated by Torah law to heal others. There's an obligation. The only reason he's entitled to nothing more than the cost of his labor, and we don't mean a labor of a menial worker. There's a formula in Bava Kamma daf 31b about how a doctor can charge. But he's not entitled to any more than that. A, he's entitled to that figure because he has bills to pay. But B, he's got a halachic obligation to heal others. So if we weren't living in a world where you have to pay bills, he wouldn't even be entitled to that. That's the one perspective, that he may not charge exorbitant fees. But according to the Ramban, Nachmanides, the second approach is that the obligation in no way bars a person from charging inflated fees. Okay, it's true, a sick person generally agrees to a doctor's fee, but it's out of a compelling need. So you might say, well, then if it compelled, you extort it. But this case of the doctors, you've got to pay. Why? Because according to the Ramban, a doctor's fee is based on his wisdom and his knowledge. And since those qualities have no fixed universal value, so to speak, you can't ever describe the doctor's fee as being inflated. So therefore, the obligation is to pay. So the halacha accords with the second approach, believe it or not. Okay? Now, I'm not arguing with the halacha, but there obviously is a bit of a difficulty. Gavin, what point did you get up in the discussion in terms of the doctor's fee?
I just went to get water. You said that doctor's fee is something about not being, that it's not really inflated or something like that, because it will be higher though, something like that. That's what I heard you say.
You may not stand up to questioning.
Why not stand up? But I wouldn't be arrested, would I?
So, Gavin, there's two opinions. According to Rashi, the doctor shouldn't even be paid at all. Basically, he's got a mitzvah to heal. The only reason we pay him a certain fee that's calculated according to Bava Kamma daf 31a, according to a particular formula for doctors, is because at the end of the day, he's got bills to pay. And therefore, that's being practical. Otherwise, nobody would choose a living to help other people. So there's got to be a bit of a balance. According to the Ramban, Nachmanides, note it's not Maimonides, who the Rambam was a chief physician of Egypt, because if he'd have asked for exorbitant fees, he had a vested interest, and the Rambam would never say anything like that. That's why it's Nachmanides, by the way. A doctor, a doctor making a commentary on doctor's fees would be a little bit odd in the Gemara. You'd say there's vested interest. That's why it's Ramban, Nachmanides. I wanted to make that distinction in defense of the Rambam. So what we are saying is here, according to the Ramban, he can charge whatever he likes. His fees shouldn't be curtailed because, let's face it, without this doctor, a person can die. So he's entitled to call whatever fee he wants. Now, accordingly, the halacha goes with the second opinion, that the doctor can command whatever fee he wants. I don't quite understand why the halacha would go with that approach, quite simply because when somebody is in a vulnerable position, if you take advantage and you want them to take out a bond in their house just to pay for medical care, it's extortion. So I'm not quite sure why it would go with halacha with that. In any event, this is discussing both the sort of principles with the ferry. Okay, so the one is that you cannot expect a person to pay you that ridiculous amount of a dinner. He was only giving you that offer to ferry him across the river because he was desperate, and therefore the service itself of ferrying is worthwhile. The other point of view is that, well, basically, if that person's saving you and freeing you from imprisonment, you're going to have to pay whatever you're going to pay to get out of it. And you made the offer to make sure he left the particular situation where you could have been re-imprisoned. So far we're saying, well, what's the Mishnah's case? The brisa is nothing other than the second clause. And what does that read? If the escapee said to the ferryman, take this dinner as your fee and ferry me across the river, he must give him his fee in full. Okay? So we are saying is that how can you have two different opinions in the brisa? The one is that he can be called into court, and when he escaped from a non-Jewish prison, say to the Jewish judge, listen, what makes you think that I really think a ferrying fee is worth that? It was because of my predicament, therefore I was in a position where I could have been extorted. The second opinion is when you say that you'd pay a dinner for the service, you have an obligation to pay. So what's the difference between this first and second clause? In other words, when does it apply? Okay, so basically the second clause is clarified by Rami Bar Chana. So Rami Bar Chana said the following. It says a ferryman who's also a fisherman. So the guy's got a fishing boat, and when the fish aren't exactly flopping in the water or swimming, or it's not the most conducive time of day, he ferries people in groups from one end of the river to another. So he says to the escaped prisoner, you actually caused me a loss of fish worth a zuz, which is equivalent to a dinner. And that amount I would have caught you in the time I spent ferrying you from point A to B. Or you could say that he could have gotten a lot of passengers had he departed at 2:30, enough to cover a dinner. So he's costing him money at this point of either the fish or that ferrying in groups. I'm just using that as an example. So the ferryman suffered a loss in the course of rendering the service, and therefore on that basis is entitled to the promised sum in compensation for his loss. So in the case of a Mishnah, since the owner of the wine suffered a loss, in order to save the honey, he is entitled to receive compensation for the loss. So if he's got an empty barrel and he's not emptying out his wine, he's not entitled to anything other than the fee for his labor and the rental of the container. But he went through a loss in this case.
Sorry, I just have to go outside for 1 minute.
No problem. I'm going to just pause the share a second. Right. All right, so guys, what we are saying here is in the Bryce's first case, the ferryman sustained no loss. Okay, he was going to leave, depart at a time from point A to B. The escapee happened to leave prison at that time. It was all according to board. No pun intended. Therefore, the promised dinner was simply an inflated price, and the passenger's promise is not binding because unless he was extorted due to circumstance, he never would pay that fee for the ferry itself. In the second case, the ferryman sustained the loss of the fish at where he uses his ferry boat to fish in the time he rescued this guy and took him from point A to point B in the ocean or the river, whatever the case may be. Or he could have picked up other passengers and he left only to make sure this prisoner escaped, and he lost out on that other revenue. So the dinner represents not an inflated price, guys, but compensation for his loss. And in that case, the passenger's promise is binding. So when the Beis states that the passenger must give the ferryman his fee in full, it refers to the dinner that was promised to compensate for the lost revenue. Okay? Now, in the Beis' case, it's not clear that the ferryman actually, for example, suffered a loss, because he's not sure if he would have caught fish in the interim at the time he took to rescue this escaped prisoner, or he would have had enough passengers to have made up that fee of a dinner, because it might have been at that time of day where passengers generally don't choose to go from one side of the river to another. Remember that passengers might have worked, if you take Long Island, or you take something where in Australia or other places where there are water estuaries, in the morning it's very busy because they're taking people from their homes to the factory across the river. There's many cases like that. And then at the end of the day, it's almost like sponsored by the company, where it takes them from the factory back to their homes across the river, especially if they're involved with fisheries and canneries. So therefore, there would be revenue loss in that particular case, but not revenue loss when it wasn't at a time where he would have sustained the loss. And if you're having a commercial endeavor and you're not taking the same employees from point A to B, you don't know if you would have customers. It's like saying, I used the movie house so that you could watch your own movie, and I lost out on X amount of customers. Well, you don't know how busy the movie would have been during the day and how many people would have paid. But even if that's the case, in terms of whether they would have lost a dinner's worth or not, it's not clear. However, if the owner of the wine barrel destroyed his wine in order to save his fellow Jew's honey, it's absolutely clear that the reason he destroyed his wine was to empty out that contents in order to save the higher valued honey of his fellow Jew. And therefore, it's not a guesstimate as to what he could have lost or made. It's an actual calculation, and it proves that has to be compensated for. Now, if, for example, so obviously it means that he can't claim for more than what he would have caught. That's according to Rashi, etc. Now, if the prisoner promises an even greater sum, that's definitely not a binding, even according to the second opinion, because it doesn't compensate losses. It's just not in the realm of reality that you pay for the service. But according to the Rosh in Bava Kamma 31b, in which we get this case of this calculation of how you'd pay a doctor, is that once a ferryman sustains even a minor loss for the fishing boat vehicle, the passenger, if he made a promise, even if it exceeds the amount of the loss, the Rosh says he has to make good on his promise. According to Rashi, no. It's only for compensatory losses. So we learned from this that if the wine owner had an empty barrel in which to catch the honey, he receives only his normal fee for what the wine is. Even if the owner is panicking for the honey and the wine is worth 1/5, and he says to the owner of the wine barrel, I will give you double what your wine's worth. It's not binding according to Rashi. According to the Rosh it is. Okay? I think that's a very, very clear argument. Now, there's another part to the Gemara, and that is as follows. There was a river that swept to, do you remember the second part of the Mishnah? I'm just going to share the screen a second. Give me 1 second, guys. Gavin, read the second case.
A river swept away his donkey and the donkey of his fellow. His donkey was worth money, 100 zuz, while that of his fellow was worth 200 zuz. He abandoned his donkey and saved the donkey of his fellow. He receives only his fee. He is not reimbursed for the loss of the donkey. But if before abandoning his donkey, he said to the owner of the other donkey, I will save your donkey, but you must give me the value of what is mine, i.e. my donkey. The owner of the donkey he saved, he's obligated to give him the value of his lost donkey.
Okay, it's pretty straightforward. So if you have a donkey worth twice mine, and I don't stipulate, then basically you only have to give me what it would cost a lifeguard to go and try and rescue your donkey. You're not entitled to compensate me for the 100 zuz that my donkey was worth, even though I saved your donkey worth 200 zuz, unless I specify. So you have to specify. So the Gemara is bringing this next point, and it says, listen, the underlying principles. Arthur, are you? Oh, let me pause you. Okay, quickly, guys. So these underlying principles are the same in the preceding case, concerning one who poured out his wine to save the honey of his fellow. So why do we have the second case? What's it coming to teach? It sounds like a reiteration of the first. And if the Mishnah only informed us of the first case with the wine and the honey, where he poured out his wine to save the honey of his fellow, we would have assumed that only in that case the law mandates that if he stipulated full reimbursement for his loss, the owner of the honey must give him the value of the lost wine, because in that case he destroyed his wine with his own hands, meaning he poured out his wine with his own hands in order to save this person's honey. But here in the case of the donkeys, where the drowning of his donkey happened by itself, it wasn't self-destructed in order to help his fellow. He never drowned his donkey to save his fellow's donkey. We could say that maybe only receives a fee for almost being like a lifeguard for that donkey, and is not reimbursed for the loss of his donkey. So the Mishnah has to state that he receives only compensation for his donkey if he actually stipulated it. Does that make sense? Okay. So perhaps then one whose donkey was saved can argue that the rescuer's donkey could have been drowned in any case. He doesn't have to reimburse him for it. So the Gemara says in that case too, the one whose donkey was saved must compensate the rescuer for his loss, but the owner of the donkey has to state that he wants his donkey reimbursed should it drown. Okay? But, so we say, okay, so we understand why we've got to learn that first case. And if the Mishnah had informed us, guys, the other way around, of only the second case in which you abandon your donkey to save the donkey of your fellow that's worth a lot more money, you could have assumed it's only in that case where the law mandates, if there was no specification that you get paid for your donkey, you receive only your fee, because the drowning donkey happened by itself. In other words, there's a probability that it could happen. There's a probability that it's not. So you have to specify that you want a replacement of your less valuable long donkey if you're saving the donkey of your fellow, because it might or might not drown. But you would assume in the case of the wine and honey, where you destroyed the wines with your own hands in order to save my honey, that even if you didn't specify that I pay you for your wine, that I must still give you the value for your wine, because you could see it wasn't a case of it might happen or might not happen. It was a definite case of you destroyed your produce worth less to save my produce worth more, and I have to compensate you. And the Gemara says it's not necessarily true, unless the owner of the wine stated that was a condition at which he save his honey. So therefore it was necessary to teach both rulings. Okay. We've got another 6 minutes left. I'm quite happy to leave on this note. I don't know if you guys agree.
You answered my question, Damon. I was going to ask you in terms of the guy on the ship, the guy fleeing, and then the honey and the donkey. The owner, or the person that's sacrificing his asset to save someone else's asset has to specify.
Yeah.
That's one of the opinions, because otherwise how's the guy supposed to know? And
I think common decency and common sense, but the thing of it is, Kevin, common sense is like a superpower. There's common decency.
it's
Not
not so
everybody
common.
has it. No, it's not common at all. You would think so. But that's why we'll end up in court. It's obvious if you back your car and hit your neighbor's car, you have to replace it. But the courts are full of people that don't fulfill their obligations, fortunately. Yeah.
Things have to be in writing. That's just, I mean, no one must assume anything, because not everyone's going to be straight
Yeah.
and honest and,
unfortunately not.
yashar, as I say in Hebrew.
Particularly doctors, as we were studying, because that's why they wear a mask and gloves like these to hide their fingerprints. It's not for sanitary reasons, just saying, with what they charge.